So, good afternoon. We are starting with our third session called Feminist Perspective on Gender, a General Context. And I have honor and pleasure to welcome and present our first keynote speaker, Professor Adrien Wing from University of Iowa College from the USA, and she joined us from the beginning of the session. So we will give the floor first to her, and then Marion, as the second keynote speaker, will speak after her. So after the first presentation, I will give an opportunity to all of you for questions. And then again, after Marion's talk, I will do the same. And after that, the whole group of our LAWGEM members and their presentations will go together, and questions and answers after that. So first, I want to introduce Professor Adrien Wing. She's the, I apologize for the pronunciation. BC, can you say BC Dutton Murray Distinguished Professor at the University of Iowa College of Law in the United States. She's Associate Dean for International and Comparative Law Programs and the Director of the UI Center for Human Rights. She's an author of over 150 publications. She's editor of Critical Race Feminism and Global Critical Race Feminism. Professor Wing teaches critical race theory and sex discrimination. She's on the board of editors of the American Journal of International Law. She holds her AB from Princeton, MA degree from USLA, and her doctorate of jurisprudence from Stanford Law School. So we really have the pleasure to listen to and to be in the academic, community with the distinguished person, Professor Adrien Wing. Please, Adrien, the floor is yours.
Thank you so much. Can everybody hear me? Yes, you can hear me?
Yes.
I think I can see me. I am very grateful to have been invited to this wonderful conference. I regret that I could not be there in person. I have just come from Paris, and next week I have to go to Italy to the Bellagio Center. And so I couldn't squeeze another international trip into my schedule, but I have been to Belgrade before, and I had a wonderful time, and I have also enjoyed working perhaps with many of you on the feminist handbook. So I am delighted. I also am happy. I was originally scheduled to go last, but for me to be able to go first in Iowa, it is 7:30 a.m. And I get up at 5 a.m. So actually, this is a very good time for me. And by the afternoon, for me, I would be very tired. So my talk today is called Critical Race Feminist Theory in the 21st Century. As you heard, I am the editor of two books. One called Critical Race Feminism and one called Global Critical Race Feminism. And so I am known in the US for focusing on women of color, and that's what critical race feminism is. I am going to hopefully share with you a slideshow that I will go through to fit the time. And I can also email this slideshow, so if people want to look at it later and read it more slowly, they can do so. So let's get this up. Okay, you can see this. Let me see if I can get it to the beginning. Okay, good. You can see that, right?
Yes.
Yes. Very good. Okay, very good. All right. So first, what I'm going to do is I'm going to mention about the attacks on something called critical race theory, of which critical race feminism is a part. I'm going to define critical race theory and critical race feminism. I'm going to give some examples, and I am going to mention some solutions to the problems affecting women of color in the US and elsewhere. Am I talking too fast?
No, that's okay.
Okay.
It's all okay.
I am realizing English is not necessarily the first language, right, of everyone. So I will slow down a little bit. Okay, so some of you may have heard that in the United States and also in Europe, I don't know if it's gotten to Serbia, there have been attacks in the media on something called critical race theory. This is a specialty I have had since it was founded in the 1980s, a small area of law focusing on race discrimination. Nobody had heard of it outside of in academia, and all of a sudden it was in 2020 in the media because the president at that time, Donald Trump, he issued an executive order on combating race and sex stereotyping, in which he called for critical race theory to be attacked. And those of us who do critical race theory were like, why? Why is he attacking us? And this was right before the November 2020 presidential election. And it was right after the death of a person I have pictured here, George Floyd, who was murdered when a police officer put his knee in the neck of George Floyd until George Floyd died in Minneapolis. And this got worldwide attention. I don't know, did any of this get to Serbia? Did you all hear about the death of this man, George Floyd? There were protests in London and Paris and some other countries in Europe, and it caused protests in the United States, and many United States universities and businesses decided that they needed to do more against race discrimination. And so it is thought that the Trump administration was very worried about emphasis from the Democrats and progressive people against race discrimination. So they decided to attack one of the academic specialties dealing with race discrimination. Okay, so these attacks happened, and anybody mentioning anything about race got attacked. And so one of the founders of critical race theory and critical race feminism is Kimberly Crenshaw in that picture there. And she said, they've lumped everything together. Critical race theory, the 1619 Project, whiteness studies, talking about white privilege. What these have in common is they are discourses that refuse to participate in the lie that America has triumphantly overcome its racist history. Everything is behind us. None of these projects accept it's all behind us. So people like me were attacked. And Kim went on to say, you know, where society racism is structured from top to bottom, etc. What it says in that slide right there. So President Trump is defeated. We were all thinking, okay, that's the end of this attack on critical race theory. But instead, what happened, even though the new President Biden revoked the executive order, the different states, you know, we have 50 states, they control education in their states. We don't have a national educational system like other countries. So more than 20 states, including the state of Iowa that I live in, went on to pass state laws banning the teaching of critical race theory in the schools, even though the laws may not even mention the word critical race theory. So in other words, the attack went from the national level to the individual states. Okay, so all of this is like, why? So what is critical race theory? And so here I have a simple definition. There are many definitions. And so it is a progressive movement originally within law, but it focuses not only on theory, but also on practical legal and political solutions to racism, white privilege, and subordination. Although it started with law, we now find it in other disciplines, history, sociology, etc. I don't know if there are people in Serbia or in your region of Europe who are looking or studying critical race theory, but maybe I will find out more in the questions. So here is more of the definition. Critical race theory recognizes racism is ingrained in the fabric of America. We're not concerned with what an individual person may or may not be doing, but how the institutions operate. So, a cartoon on the bottom. There is a myth. We all start at the same starting point. And, you know, if you don't win in education or your job, it's because it's your problem. But the cartoon is showing the race is not the same. There are some people, white men in particular in the United States, who have fewer obstacles against them compared to women of color. But people often don't see these obstacles. Another cartoon, when we were young, we were taught that after World War II, our veterans got benefits, for instance, to buy housing. But we were not told that they did not give the Black veterans these benefits, so they could not get preference on buying housing. You say, okay, who cares what happened in the 1940s? Well, if you fast forward to today, the children and grandchildren and great-grandchildren of those men are affected because one group was able to buy and inherit, and another group, my group, I am African American, we were not able to do that. So we have less wealth, not salary, but wealth that we own compared to white America. So where does the term critical race theory and critical race feminism come from? We have critical legal studies, and I'm showing you a book on the top left there, and its author, Mark Kelman, who was my professor at Stanford. And critical legal studies started in the 70s, progressive views on the law, influenced by European postmodernists. And then when people of color became professors in the 80s, they said, well, we're interested in what you are saying, critical legal studies, but you don't talk about race. So critical race theory starts, and you see on the bottom right, the late Professor Derek Bell, who was one of the founders, and on the top, you see Professor Richard Delgado and his wife, Professor Jean Stefancic. They are among the founders of critical race theory. There are many books now on critical race theory, many anthologies. They are not easy reading. They are written for people in graduate school, law school. They are not written for the general public. But if you would like to read more in a simpler fashion, the book on the bottom right with race in red, that is a relatively simple, only 100+ page reader on critical race theory. I am the editor of one of these books, The Law Unbound, which are the works of Richard Delgado. Okay, so then other people become professors, not just Black people. And so as these groups become professors, they branch out in what they are doing in critical race theory. So we have Latino or Hispanic crit, queer race crit, which is about LGBTQ people of color. We have critical white studies. We have Indian or Native American crit, Asian crit. E-crit is empirical studies crit. We have disability crit, DESI crit, critical race masculinities, and these are some of the authors. So all of these start developing among mainly law professors, but also some others. And then this leads into the focus of what I'm doing here, critical race feminism. You see there a reader, one of the readers I was telling you about that I edited, Critical Race Feminism. And we are most known in law for developing the concept of intersectionality. It was developing in other disciplines as well and in different countries, but in the US, Kimberly Crenshaw, whose picture I showed you, she is known as the mother of intersectionality in the US. So here we are looking at the intersection of not only your race and not only your gender, but also some of those other identities that you can see at the top right. In other words, I could be discriminated against because I'm an African American female. My age, I'm a senior citizen. Let's say if I was a lesbian who was disabled and I was from a working class group and I was from a minority religion. So all of those would be intersecting and affecting what would be happening to me in the society. And so this critical race feminism is drawing, therefore, from not only critical race theory and looking at structure of discrimination, but also from the regular feminist jurisprudence. And you all probably know and have heard of Catherine McKinnon, who is one of the most famous American legal feminists. And we are also pulling from Black women who are not lawyers, like Angela Davis and others who do something that some of them call womanist theory. So we, critical race feminists, are pulling from these different streams to try to focus on the plight of women of color. Among our other scholars, we have these two, Mari Matsuda, Angela Harris, and so at the top here, the identities we look at, I showed you the little wheel, but there are other identities that can be looked at, such as your marital status and language status, stature, how you look, if you're considered pretty in your society. And so why would we want to do this? Why would we want to focus on all these intersections? Because unfortunately, whether you are Black, Latina, Asian, Native American, in our society, these groups are at the bottom of our society, economically, educationally, politically, etc. So we need to help uplift the status of women who fall into these categories. And of course, we're mainly looking at the US, but the situation can apply in other countries as well. So this expands out. Today is a very important day in the United States for critical race feminists because we are getting a Black woman who is joining the US Supreme Court today. And so Judge Ketanji Brown.
Just a second. I think the connection interrupted. Okay, I think we can hear you now.
Can you hear me?
Yes, it just went off for a few seconds.
Okay, so you see the picture, right, of Justice Jackson, who today is joining the Supreme Court of the United States. So this is a great victory for critical race feminists because now we have someone like us, a Black woman, on the highest court of the United States. but it is important not only because she is a Black woman, but also because her views, her viewpoints are very progressive on subjects affecting Black people and women and Black women. So other issues that come up with critical race feminism, every area of law is affected. So for instance, in criminal justice, not only are men disproportionately killed in America by the police, but Black women are as well. And there was a Black woman, Breonna Taylor, murdered in her bed. And so there are names of other women, and often these don't get into the media, which has tended to focus on what happens to the Black men in our criminal justice system. Employment law, we have tremendous pay gaps if you look at gender and race. So for instance, at the bottom, you will see the Hispanics, also called Latinos, that Latinas, the Hispanic women, are only making $500 a week, 509, and those getting paid the most are Asian men at $952 a week. You see the Black women at $582 are a little above the Hispanics, but this chart shows you some of the disparities that exist in the United States. Then we go beyond the United States, and as you heard, I have another reader, Global Critical Race Feminism, and we have scholars who are involved in international and comparative law, human rights, international business, international feminism, etc., including people like me. So for instance, let's take another example on the global level of healthcare. The COVID pandemic showed that women around the world were disproportionately affected by it because, of course, they must take care of families. They must give up their job to take care of families. In the United States, it turned out that women of color were on the front line with the lowest paid jobs, working in the hospitals, working in the restaurants, and they had to quit these jobs, and they also got the virus at higher levels. Unfortunately, in my family, I have had over 90 relatives get COVID, 90, and 7 of them died. One was my aunt, 90 years old, Bess Pruitt, and one was my nephew, 44-year-old Dion. He had 4 children. So we have just had in the US a major US Supreme Court decision basically abolishing the right to abortion that we have had for 50 years. And everyone knows that the people the most affected by that will be the poor women, the Black women, the brown women, who will not have the money to go to a state where it is legal. It will now be handled by each state. And so women who have money can go to another state and get an abortion in the future, but not the poor women. So here is another example, domestic and global, about critical race feminism. Unfortunately, in the US, our maternal mortality statistics are horrific in the world. And it is because the Black women in America have maternal health statistics as if they were in a poor country. In other words, Black women do not get the proper care, so they are dying in childbirth or soon thereafter. And this, of course, needs to change. So, okay, I told you all these horrible things. You all know these things happen in different countries to women disproportionately. So now I'm talking about solutions. What do we do about these things? Because otherwise it's too depressing. It's what we call praxis, the intersection of theory and practice. So what can we do? In the US, I'm talking about we need to work more on national voting laws. We don't have really good national level laws. We have many state laws that discriminate against people of color. We need to work on having more affordable childcare that will help all women, including poor women. We need to have a law that helps equalize paychecks. We need to enhance the numbers of women of color in the federal government workforce. We need to work on lessening the sexual harassment. We need to work on our violence against women and international violence against women acts. In the US, we don't even have gender equality in our Constitution, so we need to work on getting that in the Constitution. There was a move to put a woman on a piece of money, and that's Harriet Tubman, a Black woman from the slave period who took people out of slavery. And that's been held up, and that would be a powerful image to have a woman, a Black woman on money. And we haven't even ratified CEDAW. We're one of the only countries in the world to not ratify the Women's Convention. And our main civil rights law, which is called Title VII, right now it's difficult to use it for women of color. You have to use it either for race or gender, but not the intersection. So these are examples of those problems I was mentioning, trying to work on legal solutions to help solve them. In my own case, as a lawyer for 40 years, my own praxis has included helping draft the constitutions of 3 countries. So I helped draft the South African Constitution, the Rwanda Constitution, and the Palestinian Basic Law. And I worked a number of years on these constitutions. And in the South African case, I was very happy to be involved with them having this wonderful equality clause. In other words, all those identities I was telling you about that critical race feminism cares about are in the South African Constitution, or just about all of them. So that's an example in my own career of something I have done. 40 years as a lawyer, 35 of that as a law professor. Another thing people can do is every country, or most countries, have NGOs, non-governmental organizations. In the US, Kimberly Crenshaw, who I showed you her picture in the beginning, she is not only a professor at UCLA and Columbia Law Schools, she has her own NGO that is called African American Policy Forum. And that entity is concerned mainly with women of color, but it also now is involved in looking at the legislation, the critical race theory legislation that is going around in the different states. So I support that group with giving money. I use their videos for my students. And so it's an example of how people can be involved with NGOs to try to make things better. Also, coalition building is critically important. And so being in coalition with you all around the world, whether it's physically or by Zoom, WebEx, or whatever we're on, so we can work together to improve the situation of women in the different countries. And I do get depressed quite a lot. I'm sure we all do. The United States is in a very horrible historical period. Things are going to get a lot worse in the US. Many of us fear we may lose our very democracy in this period to come. And it's a very dangerous period. I am worried because I am the mother of 7, and I am the grandmother of 17, with 2 more grandchildren coming this year. I, of course, am also worried as a professor. I have taught thousands of students, and they are doing wonderful things in their careers around the world. And so I want all of these individuals, and also scholars like you all around the world, to feel positive about what's going to happen in the rest of the 21st century. So for inspiration, I have many heroes and sheroes, and I will end my presentation with a comment from my hero, the late South African President Nelson Mandela. He had a saying, "The struggle is my life." He said that when he was in prison on Robben Island. He did not know he would ever get out. He was in there 27 years. He didn't know he would become the first Black president, that he would get a Nobel Prize. He didn't know any of that. None of us know whether we have one more day to live or another 10, 20, 30, 40, or 50 years. So we are not going to end racism, sexism, other isms in our lifetimes. It's not going to happen. It's not even going to happen in the lifetime of my 2 grandchildren who are going to be born this year. Instead, though, we can be judged by the quality of the struggle that we each engage in every day of our lives. And that quality of struggle will vary whether you are a young student, a young professor, a dean, a vice chancellor, a judge, or a president of the country. It will vary as you go through your life cycle and have other responsibilities. But you can dedicate yourself, as I have dedicated myself, to say every day, I will commit myself to the struggle for justice. And to that struggle, whether it be in the United States of America, Europe, or the world. So I thank you for having had this opportunity to be with you, and I will now open up for questions. Thank you.
Thank you very much, Professor Wing. So, are there any questions? People online may raise their virtual hands, or you can type something
Zara,
in the chat.
such
Zara has a question. Go ahead.
Hi, thank you so much, Professor Adrian. I was very, very happy to listen to you. Thank you so much. And I know what is happening in the US context in terms of critical race theory. And my question for you as a professor who teaches this subject, because I know that teachers and professors have been also attacked and banned to teach these kind of theories. And how do you, in your practice, how do you overcome these kind of challenges when you are in the situation to teach? Because how can you it's just I have always been having these questions how professors are dealing with this. If
Yes.
Yeah, thanks.
Well, they just passed these laws in the states in the past year. So the law in Iowa, it limits what happens in the kindergarten through the high school, but it does not limit me teaching at the university. So each law could be different. So I have been told that I will be permitted to teach my course next spring, but they could pass another law tomorrow to ban me. So there are some states that have banned teaching critical race theory on the university level. So there are going to be lawsuits where we have organizations like the ACLU, American Civil Liberties Union, who will bring these lawsuits, saying that these lawsuits violate academic freedom. In America, it's very big on the university level that people have academic freedom. It's harder to justify academic freedom in the high school level because the teachers are following a curriculum very tightly. But so there are going to be many lawsuits, and they will have to be state by state. The problem, though, is the Supreme Court now has 6 people that are very conservative. So it'll take a year or 2 for these cases to come to that Supreme Court. But when they do, they could rule in favor of the laws and against academic freedom. So that's going to make it more difficult. in the long run, but we do what we can. So there will be lawsuits, or there will be other means where people will try to design ways where curriculum could be offered, even if it's banned in a particular place. I am so worried about this. I had intended to teach 5 more years until I am 70. We have no law in America for how long a person can teach as a professor. But if they pass a law in Iowa that bans me from teaching critical race theory, I'm going to Montreal in August for vacation. And so my partner and I, we may look at Canada, as many US people are, as a place that may be more amenable to us discussing these things. Or I may decide to spend a couple of years abroad, coming to different countries and teaching for my last few years. But we cannot give up hope on this. And ironically, because of these attacks, I have now done over 100 Zoom or WebEx lectures on critical race theory or critical race feminism all over the world. And so that's positive. It's bad. They want to know because bad things were said about it, but it's good for people to then learn what it is about. I'm going to, if I can figure out, I'm not used to WebEx, to put my email in the chat because I know we can't have enough discussion here for what we might want to do. So feel free to email me, any of you, about anything I raised or didn't raise. And we can either email or we can get on a WebEx or a Zoom and talk more about these issues. I can zoom into a class or something as well. And I also will send this PowerPoint in so the group can have it as well. So does that answer a little bit about what can be done, even
Yeah,
though it's
I
not
think
very
so. I
helpful?
think so. But as you just mentioned in your lecture, there will be so many different factors that will perhaps limit people who don't have any opportunities to travel to another country or don't have the privilege of doing other stuff other than teaching, or and as a student you're not getting this sort of knowledge. So it's a little bit complex. But thank you so much for your answer.
Well, that's the glory of Zoom, and I'm using the term Zoom, generically, is that we learned, hey, we can communicate all over the world on various issues much easier than, how likely is it that I can fly to country A, B, or C. But we can do this sort of communication around the world indefinitely, unless, of course, people start blocking our capacity to do that. Are there other questions?
Yes. So,
Are there any questions? I have the question, but first I want to hear whether somebody else wants to put the question. So, okay, you have a time. So, Adrian, at the beginning you asked whether there are critical race feminist courses here in Europe or in Serbia. I can tell you for Europe, I do not know for sure, but when speaking about the region of the Western Balkans or Serbia, I am almost 100% sure that there are no courses about critical race feminism. However, I'm so glad and so proud that we invited you, and grateful that you took part in this book, which will be called, because you know that the huge book has been separated into 4 smaller ones, and ours, the first one, theoretical, will be called Feminist Approaches to Law, Theoretical and Historical Insights. So thank you for your great paper, great contribution. And what I want to say, thanking to the lecture which you gave through Zoom to our faculty staff and students, maybe it was 1 or 2 years ago, we made contact, and first you wrote that paper, and now you are with us. And so all the people here and those who will read this book, they will know much more. They will become, so speaking about important issues which are neglected in a big or smaller extent is so important. So for our region, it has already been the revolutionary step to speak about gender issues, gender equality issues in general, and then even more about critical race feminism and intersectional perspective of gender equality issue. So we are on the good way, and my question is, neither in your lecture given 1 or 2 years ago and now you do not mention anything about the communication, collaboration between feminists from different colors and of white color in the USA, and importance. For example, when I speak about gender equality issue and communication among different genders, I think that it's very important that as more male persons take part or transgender persons take part in the communication, it is better. So the same is what I think, as more white and color feminism communicate and exchange mutually critical views, that's better. So that's my approach, and my question for you is there.
Yes. Yes. So, if there can be a general feminist conference, let's say in America or like here. And so at that general conference where, let's say, it's mainly white women, there will be some people like me who are there at that conference, and we will be adding in our perspectives. So if the main speaker they are talking about domestic violence, for instance, and they may never mention domestic violence in the minority groups. And so then I may be in the audience, or I may have my own paper to say domestic violence in immigrant communities or Black communities. We won't go to the police because the police are often our enemy. So we would never think to go to the police for help with domestic violence. So in other words, we will try to integrate the ideas into the main conferences. And now that critical race feminism has been around in the US for 20 or more years, there are white women who are feminists who also will mention these things. So Catherine McKinnon, for instance, and others, they will mention about the status of women of color. Now, we also, though, we need the men, right? Globally, it is not women who are going to change the minds of all the men. We have to have men as well as women. We have to have heterosexuals as well as LGBTQ people talking about discrimination on gender identity, right? So when I raised my children, I have 5 sons and 2 daughters. It was very important to me that the boys understand the feminist issues. And I knew I had succeeded because I said one night, we were watching an American football game, not soccer, but American football. And I said, "Oh, you men in that football." And they said, "Oh, Mom, you're such a sexist. There's plenty of women that like football." And they were right. I was being sexist that all women don't like American football. And I have a daughter-in-law who's very into American football. So I knew I'm succeeding if my children will point out my sexism, if my boys will point out my sexism. So the task we have is both political and legal, but also personal, right? The feminist, that the personal is political. We start with our family and our students, etc. Does that address what you were saying?
Yes, perfect. Thanks a lot. And are there any more questions? Please.
Hello, Professor. I'm very curious about those three constitutions that you mentioned that you worked on. We have mostly been born under communist legislation around here, and it's pretty universalist from what I've seen it. So I'm curious. I think I've seen something like 15 criteria under which people should be protected by law, by constitution, on that slide in your PowerPoint presentation. I'm curious. What is it? I'm not a lawyer, so I apologize for asking a very layman question. But what is preventing legislators from just putting a blank slate on workers' rights or job security and going and pushing the legislators into being very specific about maternity leave and religion, belief, and all other criteria of discrimination that you've listed?
Okay, the signal was not very good, so I couldn't get your whole idea. Can either you or somebody, you were talking about like the South African Constitution and all of the identities.
There's a list on your slide that lists something like 15 criteria, if I remember them correctly. I'm curious, what is preventing the legislators from just putting a blank slate and just saying universal whatever those rights are?
Oh, yeah. This is a general question in law, right? You can have a clause, as constitutions do, that just says there shall be no discrimination. Right? You would think that covers everything. And that usually is how the Constitution starts. But for whatever reason, a nation will find that different types of discrimination start occurring. So for instance, in the US, we have gay marriage. I don't know if you have it in Serbia or not, but at least up to now, we have gay marriage. There will be some people that would say, if the clause says there's no discrimination, they'll say, oh, but they didn't mean about gays. They didn't mean about that. They didn't understand about that. So they will say, yes, so you could discriminate against gays. So that's why people will say, oh, no, we better add certain things to it, because otherwise people will say, look, historically, the writers of these documents could not have meant gays, or they could not have meant, some other type of person. And so instead, the trend globally is that you get more specificity, not only in this area, but in many areas, that, okay, we need to specify out, because you're writing it perhaps for generations, and you want it to be clear what you meant. And let's say, for instance, we start having clones, right? Clones of people. We have clones of animals, but let's say we get clones of people. But right now we don't have that. And so in 10 years, we have lots of discrimination against the clones. Their body parts are taken, to help their sister or their brother. So it could be that we would then say, oh, we better say no discrimination against clones, to add them to the document, because otherwise people will say nobody meant anything about clones. So this is how this can develop, and I have no idea if that will happen, but I just gave that as an example of clones as something that could happen in the future. And then we would see we have to protect humans from being chopped up for their parts to be used by other people.
Thank you very much. We have to go on with presentations. Otherwise, we could really go on with the discussion about your very interesting presentation and the topic of your presentation, but we have to stop. And now I have pleasure to introduce our next keynote speaker, Marion.
Before you do that, I just want to say thank you to everyone. I am going to turn off my video, and I'm going to stay on. And I may come in and out, or I may just go out. But in case I don't come back on and you don't see me, please feel free to get in contact. Thank you very much, Doctor. and I look forward to hearing other parts of the presentations today. Thank you.
Thank you, Adrian,
you.
very much. Sincerely, very, very much. Thank you. And be there, okay. So our next keynote speaker is Marion Röwekamp, and the topic is Feminist Legal History. And before I give the floor to my dear friend and colleague and the distinguished historian and feminist legal historian Marion, I just want to say a few words about her. So she's the historian and a full-fledged lawyer. She is the owner of the Wilhelm and Alexander von Humboldt Chair of the DAD at the Colegio, please say.
Colegio de México.
Colegio de
Colegio.
México, Colegio de México in Mexico City. Previously, she worked several times in the USA at Columbia University, New York City, then 5 Women College Studies and Research Center, South Hadley MA,
Massachusetts.
John Fitzgerald Kennedy Fellow. She how to say that? She has been the fellow at John Fitzgerald Kennedy Fellow at the Center for European Studies at Harvard, and Mexico I mentioned, and the Latin American Institute of the Free University of Berlin. Obviously, a very rich professional career and the genesis of this career. And please, the floor is yours. As I mentioned, Marion wrote an excellent paper for this first book coming out from the Springer series. And thank you also for that. And now the floor is yours.
Thank you, Dragica. And thank you, Adrian, for the really nice talk. So Adrian gave like a lecture on one area of legal studies, feminist legal studies, and I'm going to get the past in, which is another area a little bit neglected in the legal studies. Legal history in general has a difficult standing in legal departments, at least in Germany. The universities don't hire legal historians as such. They need to be trained for a real field of law, meaning civil law or public law or criminal law. And only then they will be hired. If they do legal history, it's considered only to be the cherry on the cake. It is a little bit different in Austria and Switzerland. There they hire legal historians and they just teach legal history. So the situation for them is better than in Germany. But I think it is all in all fair to say that legal history is not in the heart of the curriculum of law schools in German-speaking countries in general, and probably neither in the Anglo-American ones. Historians, on the other hand, are seldom interested in legal history, and if so, they lack the understanding of the legal system. Legal historians, on the other hand, seldom are interested in what the historians write about the field they chose to analyze. So we also have a divide here, which does not improve the work either of neither legal historians nor historians focusing on law. There are only very few people walking that small bridge, like the historian Michael Stolleis did, who recently died. He has been a great scholar and a great person, crossing not only the bridge, but also he had the ability to write a very beautiful narrative, which is also not that often happening in academia. He believed, and I personally do believe, that legal history is of utmost importance because law is not set as such and as it is taught. For me, studying the law was like an unmovable block because I never thought about the fact that the law and legal institutions are not fixed, that the law is not sacred as I felt it was made in the interest of mostly a handful of white men with influence in their interest. The Irish female lawyer Marion Duggan formulated her findings quite strongly already in 1915. Here is her observation of the legal system. I'm citing. I always think that the results of our legal system might be classified as follows. Towards rich men, it is absolutely satisfactory. Towards rich women, generally satisfactory. Towards poor men, unsatisfactory. And towards poor women, very unsatisfactory. The citation shows legal history does raise doubts about legal certainty and lessens the awe we have for the legal system. It is subversive in its nature because it can lead to the realization that law in the end is arbitrary and that the environment legal students are socialized in is a historical construct only. When I learned while reading law in my third semester in Heidelberg that someone criticized the famous German civil law in the early 20th century, in fact that women did, it was an eye-opener for me. And I have not yet fully recovered from that after decades working in the field. I must constantly tell myself that the lines the law draws are a construction and that I need to look and research beyond these divides, again after decades not even working the law as a lawyer, more as a historian with legal knowledge. It is a very strong formation. No? It is a very strong formation students receive in German legal education. It is changing the way of thinking as far as the law is concerned and often also beyond. And of course, the lesson subsurface legal history is nothing a state necessarily wants its legal students to learn, especially not as the German state, who still follows the education of the so-called Einheitsjurist, which finds no good translation into English, one may say a uniform jurist. It means that all law students are going through the same legal education, no matter which profession the student would like to pursue. It was set up from the German state basically to get reliable civil servants, and unfortunately hasn't lost the basic line of thinking until now. Meaning the legal education in Germany serves the state up until today. And as far as I know, there's no reform in the pipeline to change the education to recruit streamlined civil servants. Even more important, it is a critical appraisal of legal history and the state in a country such as Germany. But now I have spoken more about legal history and the need of legal history in general, yet probably most of you thought to yourself, the jump from critical thinking of the law to women's legal history is not hard to make. And in fact, it is not. If legal history can be combined with social history of law, exploring how the law is shaped by interests and how legal institutions and society as a whole are shaped through the law as a tool, we have to almost end blindly hitting our heads on the question of women in legal history. Okay. Or maybe the history of partially legal history, because the law of women has been for centuries, and here I have the German feminist Johanna Löwenherz talking, the law of lawlessness. The law claims it does treat everybody equal and alike, and thus have a kind of fairness towards everybody. Let's hear what Löwenherz has to say about that in 1895. It is said, all Prussians are equal before the law. Does that mean every female Prussian is considered as non-Prussian before the law? In some countries of the Orient, the national language is spoken by men and women in two different dialects. The man speaks one dialect, the women the other. Does the law in our country speak two different dialects to men and women? Citation end. It did, and it still does. But it is much stronger than that. It is more that there are different interpretations of the law, but different languages. And in the law, treated women and men in big parts different by claiming that especially married women were not represented by themselves in the law, but by their husbands. And here I would like to introduce Swiss lawyer Emilie Kemping thinking about this in the observation in 1882. Citation. And her political right, her civil right, she has none. As a citizen, the woman does not exist. The rights of the citizen consists in the fact that he may elect delegates to represent his interest within the respective government, and that it is his right to confer with the peers about the interests. This is expressed when we say that the citizen who is in full possession of his civil rights has, first, the right to vote, and second, the right to coalition. These rights can be temporarily withdrawn from the citizen who has otherwise committed a serious offense against the law, meaning to see the so-called criminal. Neither do the profligate, who is under curatorship, the minor, the insane enjoy them, and none, of course, does the woman. It is quite strange how it is with the civil rights of the woman, for when I just said that she has none, it occurs to me afterwards that I was mistaken. Sometimes she has civil rights. She has the right to pay taxes, but she is not authorized to decide on these taxes and their use. Is that not strange? If only I could fathom the profound wisdom that lies in this granting of citizenship on the one hand and its deprivation on the other, but it certainly does lie there, otherwise the institution would not have been made in the Prussian state. Of that I'm firmly convinced, if only I could fathom this profound wisdom. When I read these women's voices, I often think I don't have to add my own voice anymore. It is already said and done. But as I'm today not only here to have you listening to the voices of women of the past, as much as they already had it clear, I'm going to put in a grain more about this research on women's legal history, which has started roughly in the 1970s with a renewed recovery of the generation of 68 that in fact there exists a woman question. Translating this observation in the question of the past, mostly female historians observed that legal history had ignored women in the past and does until today only tangentially deal with them. When legal history is not at the focus of law schools' curriculums, it is even far less the case for women's legal history. I don't believe there has been more classes taught in Europe on this topic than I count with my two hands, probably not even with one. Also, within general women's history, this kind of research questions remain on the margin, often because there is not a lot of researchers fit in dealing with these questions. But still, despite of all these obstacles, there is a broadening field of women's legal history. So what do we women's legal history historians exactly do? It is about questioning assumptions about the situation of women in law or in lawlessness. Dagen, Löwenherz, and Camping, as many other women in the past, have already questioned the myth of law, uncovering the claim that law is based on equity and fairness and showing that in fact it is structured around man, power base, and patriarchal precedents. They saw as clearly as we do nowadays that the law has been, and in many cases continues to be, based on male norms made by men, defined in male terms and interests. Kempin has stressed not only that those women possessed only rights when it served the state, that they have them as in criminal law or in tax law, but she also pointed out how tricky women were constrained by the law. On one hand, they did not possess a full civil personality, at least married women did not. So they could, for example, not contract, did not possess the parental power over their children, and they could not sue in court. And on the other hand, they could not vote and thus could not influence their legal situation in the parliaments. One missing legal freedom inflicted on the other, and taken together, women had no legal measure how to get out of their discriminating legal situation. The German historian Gisela Bock has called that the double bind women could not easily break out. It was set up to keep them at home in the family. In fact, research in the last 50 years has shown that the setup of the liberal state strongly relied on the idea of gendered spheres and the gendered state. The assumption that women stay at home and raise children while the men dedicate themselves to the public realm is one of the founding assumptions of the modern state, without almost any male thinkers of the state, the law and philosophy mentioning that in their famous thoughts. So, women's legal history, as US lawyer Phyllis Batlin has said, serves as a mode of analysis that can expose and controvert some of our basic assumptions about citizenship, law, and the construction of the liberal state. Women's legal history does by force focus on the question of power and hierarchies. They uncover the mechanisms by which men have retained power for themselves in the law, as English scholar Rosemary Ochmuti has phrased it. Focusing on gender shows how power slashed through the law in terms of legal reality, of how the law touches its adversaries in different ways, and produces imbalances that exist both explicitly and implicitly within the structure of law and through the legal and non-legal actors. Like class, race, and age, it is one way through which power articulates itself and becomes systematized as well as legitimized. By analyzing these mechanisms in the past, we become able to adopt new approaches to change the law. In fact, recently most studies stress the fact that women were not only constrained by the law, but also show how they used the law as a tool to obtain personal and societal change. We find situations in the past and the present where women were able to remake existing legal norms and transform the law itself, as we heard in the morning. Like that, women altered traditional legal concepts and reconceptualized basic notions of fairness and justice. In the same way, legal feminists and theorists use the legal history of women to incorporate their findings in their ideas how to change the current laws to make it more equal for women and men. Doing women's legal history underscores, as I have already hinted, at the need for interdisciplinarity, as again Phyllis Bethlin phrased it, because the law reflects societal understandings of gender while simultaneously constructing such understandings. It needs a broader use of sources, a broader use of methodological, of research questions to include new legal actors and new ways of thinking about how the law worked and works. With the recognition of differences, we can use this space for creative and productive thinking about women and the law in past and present. How do we female legal historians do that? Mostly, we locate women at the center of historical understanding of the past, and thus writing the women and their perspectives into the dominant history of the law. We attempt to deconstruct and dismantle the law as it appears to be valid, to explore the deeper structures and beliefs underpinning those regulations, exposing patriarchy's smokescreen. Then we attempt to reconstruct or rewrite the history without the assumption of male bias that so far have infused the interpretation of law and legal history. There are different kinds of approaches to the methodology of feminist legal theorizing, the equalitarian or liberal one, for example, the one of difference, dominance, and the postmodern one. Due to the time frame, and because we do have extra talks on it later, I'm not going to go into each of them, especially since I personally believe in a combined approach, observing that women in the past also have usually used a combination of approaches. Only later research has drawn the approaches apart and cataloged them in different drawers, which does not do justice to them and to the women of the past who used them and also categorized wrongly in their way of thinking. Instead, I would like to introduce another woman of the past, the US historian, American feminist Elizabeth Cady Stanton, talking exactly about this issue in 1868. It matters not whether women and men are alike or unlike. Women has the same right as man has to choose her own place. She explained, we started on the equality ground 20 years ago because we thought from that standpoint we could draw the strongest arguments for women's enfranchisement. And there we stood, firmly entrenched until we saw that stronger arguments could be drawn from a difference in sex, in mind as well as body. Here we find someone who sees the approach pragmatical, not ideological. I fully agree to that and perform in my research what law professor Mary Becker calls a pragmatic feminist approach. Rather limiting myself and the women of the past to one approach, I see the different methodologicals as a set of tools to use. So what happened so far in a very brief way of description in the field of women's legal history? We legal historians of women's history in law have discovered complex ways in which the law on one hand discriminated women in law and the contradictory responses to women's claims to autonomy and empowering themselves. We have discovered recently as well that the reading of women's history in the first and second wave and into a linear progress towards the eradication of barriers in an interpretation does not consider the steady ebb and flows which we even can discover in our lifetime. The years of the pandemic have made us aware that the rights we possess are not for granted and can be withdrawn in a blink. We learned that in a moment of crisis, it is not only the moment of the executive power, but also of man. The few findings already hint a new understanding of the past and the present, gained by research in women's legal history, even within the time of us doing women's legal history. We have changed the reading of history already considerably. Still, women's legal history is somewhat sketchy and missing huge fields still to be filled. It is a work in progress. But there is, of course, the other obstacle that these findings are not necessarily perceived and included by male historians or legal historians who tend to see women's legal history as a separate field of research and independent from their interpretations. In this sense, we are far away from women and men being both part of an integrative common history, legally seen or in general. That one is a challenge that remains for the future, but according to a report of the Global Gender Gap Repair of the World Economic Forum, I believe we still have 136 years left until women are supposed to have gained equal rights in the globe. Maybe by then, we also have a common history of men and women, including children and different minorities as well. Thank you very much.
Thank you, Marion. Please, questions? Tanasie? Professor Tanasie Marinković, I apologize.
Thank you very much, Marion, for your interesting presentation. I have actually a number of questions, but I'll try to limit them. So how deep do you go on the basis of the extract that you have shared with us? It looks like you're concentrating on the second half of the 19th century and the beginning of the 20th century. How actually deep does feminist legal theory go? I mean, feminist legal history go with the research? And what are the challenges that you're facing in that research, undigging the parts of the history which have been, as you have said, completely where women were invisible, actually. So how challenging it is in terms of the research. And secondly, the question which I had even before you mentioned the integrated common history. Are there? You said so far there are no common histories, but at least is there for certain parts of the history an attempt to make a common history, an integrated feminist and male dominant understanding of the history. So, are there any attempts to do it at least for certain parts, certain periods of the history, if not for, of course, longer periods? Thank you.
Of course, I cannot answer that question for the entire globe because I'm not aware of all the history being written, especially not if it's not in a language that I speak. And that brings me, let me first answer that. So in the fields that I see, the history is still like pretty separate. There are, of course, attempts to include women's history in bigger projects, but it always comes like a special part of it. And a common history would be if men are including women just as a matter of fact, as women are including men as a matter of fact. That we don't have to say that is women's history, but that is our history. And from that, we are still very far away in general. Of course, that is part of the problems and the challenges that you have in the field are, like always in history, the sources. And as history has been written basically by men, it has been also more usual that men are writing about their experiences, that women are like expressing them. So we have a problem of finding sources that answer the questions that we have in the past. And that is why I also concentrate on the end of the 19th and 20th century, because here we see it that women are starting to express themselves more publicly, and we do find more sources. Of course, what is happening is that women use different kind of sources than usual or common history usually uses. So you're like analyzing, for example, dresses or pictures, and and carpets and different kinds of sources that common history usually does not need to use because they have enough sources to answer the questions. That makes the field much broader, and oral history, for example, is a part that is also included, especially in that area of history. But of course, that is also related to people who are still alive. So what you see also they use not only more sources, but they use also different sources. And that also raises, of course, the challenge of writing the history and make it in the eyes of many historians and legal historians also not professional, because the definition of what can be used to write history is still very limited to the ideas of male historians, which sources are okay to use. But of course, there's a postmodern turn and things can be included. So things are going, but they go slow. And of course, there are also historians who focus on the time before I focus, and especially the research on women in early modern history is excellent in that field, but that's not the time I focus on. But it exists, and they are often methodologically very on the first ones who introduce new things, and we pick up on them. So it does exist. But it is still a separate field.
More questions? So if I may, Marion, ask you, maybe this is a little bit kind of a digression, but still what I consider as the most important from your paper, maybe if you don't mind, just mention that in a summing up way. I like that explanation how at the same time when and how the public law and right to vote expanded, immediately the reaction was limiting the field of the family law to the patriarchal background. So just say a few words, because that's so important dialectic which has been going on then in 19th century and later on. Thank you.
And that is in fact the beginning of all the liberal theories of the modern state. And in that time also the idea of the separation of the spheres became very strong, that men are working in the public and women stay at home. And that is like the basic idea, in my opinion, that lays on the bottom of the liberal state. I mean, as I said in my talk, male thinkers usually don't mention that, but it is such a matter of course that they don't mention it because they also don't want it to be seen, especially by women. So what happened very much in the end of the 19th century is that the social realities of women changed a lot. Women became like working outside of the home a lot. So in the reality, the situation already changed and the law did not change. And what the bourgeoisie did, because that is like the same time when the middle class became strong and wanted to gain their own standing in the society, they made a new law that was like cut out for the individual. That is pretty much what happened in all the civil laws at the same time in most of the European countries, at least. They also limited the power of women. So with the Enlightenment came up the idea that everybody is equal, and some people even said men and women are equal. But what happened there is that the enlightened legal codes, like the Code Napoleon, like the German law, the Austrian law, they stopped the gendered ideas that women are not the same as men in law. So women first time became equal legally seen. But what happened in the same moment is that they reintroduced the legal discrimination for married women, so that women who were like marrying lost their legal personality immediately again. It was a kind of twist. So single women were doing better legally seen, but they were of course not able to vote. So they had still one lock that they could not get free with, but married women were like in the dialectic position that they could not do anything to free themselves, neither in civil law nor in public law, because they had no voting rights and they had no rights in the family. So what many women argued in that time was what later scholars called the legal difference idea, that women are different and as mothers they needed more rights to raise the perfect citizens. And that was an argumentation that men also could understand, that they within the family needed more rights to do their work better as mothers and as wives of husbands. So that is how the education for women more or less started. And with that came, of course, like a expanding of women's rights, like slowly. So first they argued for more rights in the family. Then they said like, yeah, but what we do in the family, raising the kids, we also can do for the society. So they went into the welfare. And here they expanded the rights already in the public area. So it's just blowing up like slowly until women started to claim openly for public rights, also suffrage rights. That was in many countries, like the Anglo-Americans. They started really early with that because they had a different understanding that of men and women, and that women in principle are equal. So it was the English women and the American women early on pushing for suffrage rights, while, for example, the German women were like, I mean, we are for that, but we better don't say it because we are going to make our chance less or worsening our chances. So they kept pushing for laws in the family, which in my opinion is like the bigger obstacle in any case. I mean, that is what the women also didn't understand at that point of time, that the bigger obstacle will always be when the family is concerned. So women in the end got suffrage rights far long before they got equal rights in the families. That came all over the Europe and the world in the 1970s, and we're still not there today. So the idea of suffrage in the end helped a lot because women could go into the parliaments and start working for legal changes of women for equal rights in all the areas, not only in the family. But the family, in my opinion, is the most stubborn one, and one that we're still confronting today, like in Germany, for example, an unequal tax law, in no help for single women. I mean, the area of laws that still need to be changed is still exists, but what of course is much stronger than that is that the mental change is cannot be enforced by the law. Here we see the limits of the law. The law can help making legal changes. It can hinder legal changes, and we have seen all that in women's legal history. But right now we confront something new, and that is that we have to change mental obstacles. And that is probably the most stubborn part. Yeah.
Thanks a lot. My question was not so good as your response. Your response was fantastic. Thanks a lot. Any more? Tanasia?
I don't want to monopolize it. If there is no one who would like to pose a question, I have one more. What are the
louder?
Yeah. What are the main angles that you take in the feminist legal history? What are the main topics that you address due to the fact that women were, as you said, isolated in the private sphere, and that many issues that we discuss in the dominant legal history, basically women are once again invisible, they're not present because they're de facto not present. So is it like a history of private lives, more focused on those aspects, or what is the angle that you take? What are the topics that you address? How much is that history different from male in methodological sense, if I can put it?
Well, the history is totally different because I address parts of the law that male lawyers usually don't address and not even see. I mean, nowadays we do. The entire conference is about that. But in the past, there are still like very few people looking in how this developed. And that's why I believe it is very important to look also backwards because, like I said, like a bit jokingly, the 68 discovered the women's question, and they really believed they did until they started to look back and see that women already have raised the same questions already for centuries. And we can avoid mistakes. We can see that, for example, the battle of equality and difference, which we fight nowadays like bitterly in feminist legal studies, is a question that women have already fought for a long time and maybe already answered. Maybe there is no need to fight about them. So what I believe is it is very necessary to look backwards to see how women did it and to avoid the same mistakes, but also to understand how really the setup is, because if we are not seeing that this is already history that is in the basic of the liberal state, we will not be going into the depth that we need to change it. We just will be on the surface. So for that, I think we need legal history a lot. And I personally, I'm also a big jumpy in that. I'm a lot doing family history, family law history, because as I explained, I believe that is one of the Knackpunkte, we say in Germany, the junctions where politics is decided, and much more also than male histories believe. Because you see, for example, in all the debates in the Weimar Republic, you always believe that is like women's stuff and it's not that important. So it's social, blah, blah, blah. But in reality, it is a big chunk in the center of history, because it is about the changing of society and about the negotiation, how much power when men and women have. I personally, I don't believe, I know it is true, that this is like the angle everything hangs on, but it seems like not so many people have seen that point. But I'm also doing a lot of international history now, like seeing where is the influence of women in formulating international law, which is also an area which is hardly written yet. Male history, legal history writes the history as a story of male legal historians formulating the international law. But if you look better, you see that women are like in the background and like in a parallel universe already doing it at the same time as men formulated international law, just the history is not written yet. And what we need in the end is, of course, to write these histories together. I'm also doing the same, of course, because I'm only writing the history of women, I mean, which is always touching the one of men, but I also know that this is incomplete. We have to write it common. But since this history does not yet exist, someone has to write it first in order to combine them.
Thanks a lot. And now I think that we have to go to proceed with the next presentations, but the difference will be these two fantastic keynote speeches had also the privilege of introducing questions and answers immediately after the presentations, but they were so good. However, it does not mean any underestimation, but just for practical reasons, the presentations of our very interesting chapters from the textbook, 4 of them, they will go one after another and they will last much shorter. And then we will have all of us an opportunity for questions and answers. We will start with the chapter and presentation of chapter mostly connected to what Marion spoke about, gender perspective in comparative legal history. Nina Kršljanin will present very shortly that chapter. Chapter is huge, very complex, and I really wonder how she will manage to make it, but she will. She will manage. So Nina has firstly the floor, then there will be Fabio Macioce and Antonio Alvarez, and then they will speak about feminist political and legal theories chapter. Then we will have Sociology of Law and Gender Equality, Zara from Örebro University and Valerija from our university. They will speak in a combined way. And feminist methodologies and gender research, Zara again. I apologize, I cannot correctly pronounce her surname, so Zara will say that I don't want to risk and make too big mistake. So Zara Saeidzadeh, something like that. So first Nina, then Fabio and Antonio, then Zara and Valerija, and again Zara, and then questions and answers. So please.
Thank you, Professor Vujadinović, and I do want to thank our keynote speakers who spoke before me, and particularly Marion, who gave a wonderful general overview of what it is like to address gender issues, and in particular women's issues in legal history. And now I'm going to focus on how our team handled the chapter in the textbook. There was 5 of us writing the chapter, 3 of us from here the University of Belgrade Faculty of Law, so Voja Stanimirović, Una Divac, and myself, and two teachers from the LUMSA University in Palermo, Professor Pietro Loiacono and Professor Maurilio Felici. We divided the parts that each of us was going to write, but either way we had a relatively tough task before us because the subject matter that we were supposed to cover was huge. So technically we were supposed to talk about gender issues of various sorts in all areas of law in the entire legal history of mankind. And that was supposed to fit to 20 pages, I think, and fortunately the editors allowed us to overstep that limit somewhat, but still we were hard-pressed to find that golden middle ground where we wouldn't just give some very brief notes to the students, but we wouldn't swamp them with information that they wouldn't be able to remember or to understand. So what we tried to do, and I'll talk more about what we did than the contents themselves, because you'll be able to read the book soon. It will be an open access book, so you'll be able to read it for free online. We divided our chapter into three periods: the Antiquity, the Middle Ages, and the Modern period, with an introduction and conclusion, of course. And we adopted a different approach for the pre-modern periods and the modern one. In the pre-modern periods, we focused on key legal systems, on civilizations. So, for example, in the Antiquity, we have ancient Egypt, ancient Mesopotamia, Rome, Greece, and the Jewish law of the Old Testament. We didn't go into legal systems that are too exotic for us, so we didn't cover, say, the Far East and so on. We mostly covered Europe and the Near East, and in the modern age we also touched upon the Americas and Australia as well. Generally the approach was broader in the modern age, because in the modern age we decided not to go legal system by legal system, but subject by subject. So in modern age we talk about women in family law, in their property rights, women in criminal law, public law, and fight for women's suffrage, and so on. Now, I keep saying women, and yes, the greater part of our focus were women, because generally when we speak about gender issues, naturally the key problem throughout most of the history was that men had more rights than women. But we also tried to highlight gender-specific issues that were specific to men, and to show the difference in the status, and also where it was available, where such categories existed, the situation of people who were not quite men or women. For example, in many pre-modern societies, you had eunuchs who were technically castrated males, but were not considered fully men, and sometimes their legal rights were limited. In many systems, they could not marry because they could not procreate. In some systems, they could marry, but they could not adopt children, and so on and so on. Any similarity to some modern issues is, of course, noticeable. So gender history is not just women's history in this subject, but of course the issue of women's legal status is the central one. Another important issue that we tried to broach throughout the chapter was intersectionality, that Professor Wing talked about so wonderfully. The fact that we can't talk about the status of all women in a given society, in a given legal system in the same way. It's even more true in pre-modern societies, because there in the ancient and medieval legal systems you have those differences not just in practice but written down in the law. So women of noble standing, not just women of course, both men and women have different rights and duties compared to commoners, and then again free people, different ones compared to slaves, and so on and so forth. When we come to the modern era, the situation there gradually changes to that of practical differences, though of course we have slavery in the modern era as well, and that's also an issue to be considered. We have um, discriminatory legal systems in various colonies of European powers where the local population is discriminated against, and then of course you have double discrimination if you're a native woman. So those are all very complex issues that we of course could not all analyze in detail in the chapter, but we tried to give an overview, to show some key points, to give the students some most important facts and some subjects to think about, some things that aren't just already carved in stone as truths that they have to memorize, but issues that they could raise, questions they could ask. Whether we have succeeded or not, we'll see upon the publication of the textbook, but generally we tried to adopt that approach. Two more short things that I'd like to say, and then I'll finish because we've been warned about time. First, it is interesting to note, perhaps not such a surprise to those who are already versed in the matter, but it frequently comes as a surprise to the broader audience that those systems that are frequently very famous, very lauded for some aspects that they have developed so well, for example, Roman civil law or democracy, be it in ancient Greece or in modern parliamentary England, have a very, very bad legal status of women. It's not always the case, but very frequently those systems where men lawyers have developed some wonderful institutions that we use nowadays with some modifications were very strict in limiting the rights of women, while, for example, ancient Egypt, from the legal system of which we haven't really inherited much worldwide, had almost gender equality by the standards of ancient history. Naturally, in practice, the family was patriarchal, the women were more often doing female jobs and so on, but legally, women could be lawyers, women could be generals, women could be anything. You don't have anything like that until the modern times, and so on. Another thing I'd like to point out is that the key in these gender issues is evolution. So you can't make a jump, a revolutionary step from a system where women have no rights whatsoever to complete gender equality. Even if you wrote laws that are such, the practice would not follow with any noticeable speed. But also, there's the problem where sometimes a big step forward is made, but then that solution doesn't change for a long time, and then some centuries past, what was a progressive solution becomes an obsolete one. For example, with the rise of Islam in the Near East, what Muhammad did for women was revolutionary. Women used to be practically the property of their husbands. They used to be inherited after their husband's death. Daughters also had no significant rights. And Muhammad comes in, the Quran says that any woman receives half the share of a man. So daughters inherit everything, including land, just at half the rate that men do. That was a huge step forward at the time. It was more advanced than many European countries at that time, but when it is still applied nowadays, it's discriminatory compared to the standards that some other countries have developed in the meantime. So these are just a few examples. There are many more intriguing issues in the chapter. I hope some of you will read it when the book is out. If you have any more questions, I'll be happy to answer, but I won't take up any more of your time right now. Thank you.
Thank you, Nina. So Fabio, if you hear me, first you and then Antonio, if you don't mind. Here he is.
I hope you hear me.
We hear you.
Okay, thank you very much. Order of presentation.
We hear you, but very quietly. Could you lower your microphone towards your mouth if it's the microphone on your headphones?
So
It's lifted. We hear you, but it's very quiet. You have to speak much louder. We can almost cannot hear you. We hear you, but we cannot. On your headphones, lower it towards your mouth, please.
Okay, I can try to speak louder. I hope you can hear me now. Okay, so thank you for let me briefly present my chapter. In the chapter I've written with Antonio and Sophia Street. We were three authors, and the chapter is divided in three parts. The first one is devoted to exploring the concept of feminism, gender, and patriarchy. The second one is devoted to the analysis of feminist political thought, and the third one is the part devoted to the analysis of legal feminism. I don't have the time to explore this chapter in depth, and not even the third part, which I've written more in detail. So what I want to do is to give you an idea of this chapter, and then to briefly reflect or analyze just one concept, which is quite interesting because it can highlight the fecundity of feminism, of feminist legal thinking, also for other questions that not directly concern women. So when we consider the aspect of legal feminism, of course, the effects of patriarchy came to the fore. Feminist scholars devoted a wide range of studies to the analysis of the influence of patriarchy and patriarchal norms on the condition of women, extending to those who do not conform to these male, heterosexual, and cisgender norms, and analyzed legal systems and institutions, starting from the recognition of their intrinsic patriarchal structures, which creates a subtle duality between men, who are the subject, and women, who are the other. According to a useful distinction, we highlighted in this chapter three approaches of feminist positions on law. The first stage, the first approach, can be epitomized by the phrase that law is sexist, the second by the phrase that law is male, and the third by the phrase that law is gender. Therefore, starting from the recognition of the patriarchal orientation of law, the first approach, or the first feminist legal scholarship, focused on the consequences of patriarchy in terms of exclusion of women from public life, what some scholars labeled as a male monopoly of law. Consequently, the space and patriarchy within this approach took the form of the quest for equality in the professions as well as in politics, attempting to remove existing rules that operated to the detriment of women, without criticizing the basic assumptions of the legal system itself, so its consideration of subjects as gender-neutral individuals, holding gender-neutral rights. It is in the second phase that legal, or in the second approach, that legal feminism explicitly addressed the male orientation of law. Feminist legal scholar criticized impartiality and objectivity of legal systems, uncovering the male standards and assumptions that permeate these concepts. McKinnon, for instance, argued that ideals such as objectivity or neutrality, which are typical of Western legal culture, are actually masculine values that have been taken as universal ones. Similarly, feminist legal scholars highlighted the male standards underlying criteria such as that of the reasonable person, which is really important in penal law, and how these standards mask male constructs and male standards, thereby consolidating male dominance. A third approach or phase is not just a temporal subsequence or sequence. The third approach does not simply question the gendered structure of society and legal system, but the role of law itself, adopting postmodernist philosophies and deconstructionist approaches. In this approach, the impossibility of reducing the condition of women to a single set of factors is emphasized, and the possibility of highlighting essential elements useful in defining the condition of women is questioned, highlighting instead the importance of factors such as class, race, age, physical ability or disability, and so on. And some scholars have pointed out, as some scholars have pointed out, that the constructionist approach tends to question certain assumptions of previous feminist theories, and in particular, the implicitly white, heterosexual, and middle-class point of view that underpin this theory. For instance, the substantial irreducibility of the experience of women of color to that of white women is sometimes reaffirmed, including the impossibility of talking about patriarchy and the oppression of women in general, and the need to include different experiences and point of view in the debate in an intersectional perspective. At the same time, other scholars pointed out that patriarchy and oppression as theorized by prevailing theories presuppose an underlying heterosexual binarism, which neglects the condition of lesbian women and their needs. In some same way, postmodernist theories deconstruct the very concepts of gender and sex and the same binarism, men, women, subject, other, oppressed, oppressors, that they presuppose. All these issues and topics have been described and analyzed in the textbook. As you have said, the textbook is designed or has been taught for students and for professionals. So there is sometimes an approach that is typically academical. Here, I don't want to describe in a detail all the concepts that we analyzed and the things that we described and discussed in the chapter. What I want to highlight is just one aspect, and this aspect is the importance or the fecundity of feminist analysis of oppression and power asymmetries for the development of a greater sensitivity toward the condition of vulnerable groups in general, not just for women. It is well known that feminist analysis highlighted that besides the specific legal discriminations, women face a more fundamental condition of oppression that hinders women's participation in public sphere and puts disproportionate burdens on them. If we want to take a contemporary example, we can mention the condition of women in clinical trials. The same could be said in very similar terms for elderly and members of ethnic minorities. This condition does not depend only on subjective conditions and individual traits, but originates also from the fact that the clinical and pharmacological research system structurally tends to underrepresent women. are considered, males of Caucasian origin are considered as the normal study population, or the assumption of a male point of view in the conduct of the study, and thus, for example, in the formulation of informed consent templates and procedures, or the idea that physiological differences are a negligible factor in drug response, or the idea that women are more complex and more costly subjects because of their changing hormone levels. Other factors are at work, and of course, not all of them are understandable in the logic of oppression. But these factors produce a condition of vulnerability for women fatalis, exposing them to risks that range from a higher incidence of adverse reaction to drugs or over medication linked to dosages that are calibrated to the male body and not to the female one, or the use of informed consent models that are designed for the so-called neutral and universal male individual. I said that that feminist analysis have a very deep influence also in analysis for other groups. If we take Marion Young's words, the discourse of liberal individualism denies the reality of groups. These individualist ideologies, this morning we talked in a question about the question between individualism and group perspective. But individualist ideology that is typical of of contemporary liberalism obscures oppression. Without conceptualizing groups, in some sense, it is not possible to conceptualize oppression as a systematic, structured, and institutional process. In this vein, if we come back to the example, the exclusion of a single woman from a clinical trial or a member of an ethnic minority could be either justified due to individual factors or unfairly discriminating is motivated by prejudice. However, when we take a group perspective, power mechanisms and systemic prejudices that every woman experiences become perceptible. For instance, the fact of being induced to take drugs which are tested mainly, if not exclusively, on men. This is an approach that is very important and that is linked to decades of feminist scholarship, feminist legal scholarship. And it is interesting because in more recent times, for instance, European courts of human rights started to take a similar approach when considering the condition of what the court calls vulnerable groups. In the case law of the European Court, for instance, the particular vulnerability of certain groups has been used to justify the application of a stronger interpretative mechanism concerning the need for specific forms of protection by public institutions. And this has been done by determining a stricter standard for the definition of degrading treatments, or by widening or facilitating the admissibility of individual complaints, or by reducing the margin of appreciation of states. So what is at stake is that when the European courts use this category of group vulnerability, it uses arguments that are consistent with decades of feminist analysis of oppression. When applicants belong to a vulnerable group, the health treatments that are close to them should look weaker and should be balanced from an asymmetrical perspective. By taking the vulnerability of groups into account, the court should shed light on social relations, on access of oppression and privilege, and it asymmetrically balances the needs and claims of those who speak from the less privileged perspective. I think this is something that demonstrates the perpetual fecundity of feminist analysis, at least in the legal field, which is the only one I know,
Oops. Hi, thank you very much. Good afternoon, everyone. My name is Antonio Alvarez del Cuvillo. I teach labor and social security law in the University of Cadiz in Spain. First of all, I would like to thank the organizers of this event, especially Professor Vujadinović, Dragica, and also the Faculty of Law of the University of Belgrade for the invitation and the opportunity to share some ideas with you. I was asked to give a 10-minute presentation. I think I have to be shorter. I don't know, but you can, Dragica, you can say. Okay. The chapter is about feminist political and legal theories. This is a long topic, so I have chosen to focus on only one topic. And I have chosen to focus on the feminist critique of the concept of discrimination, because much of my research along my career is about discrimination law or anti-discrimination law. And I'm really interested of knowing what feminists have to say about this. But let me start with a preliminary question. Should the concept of discrimination be criticized from a feminist point of view? Because feminism could be defined as an intellectual and political movement aimed to achieve, for example, equality between women and men. And we could infer that the legal concept of sex discrimination has exactly the same aim. So in that vein, we could say, okay, the prohibition of discrimination is a feminist category, so why to criticize it? Nevertheless, there are some feminist authors, for instance, Iris Young, that has been mentioned by Professor Macioce before me, that point out that the real issue, Fabio has talked about this, is not discrimination or women's discrimination, but women's oppression. Or we could say subordination or male domination, etc. So it's a matter of power, not just a matter of equality. These authors claim that this concept or the concept of discrimination does not point to the heart of the problem, because it focuses mainly on the agents rather than the victims, and on individual cases rather than the systemic imbalance of power. We have talked about this in the morning. The logic of discrimination tends to be applied to particular cases in which the agents can be identified and held liable in court. And this is important, in which the victims can actively mobilize their rights. That kind of individualization and the politicization of women's oppression may contribute to obscuring the actual issues at hand. Certainly, these authors recognize that the concept of indirect discrimination or disparate impact could have some potential in acknowledging systemic subordination, but in the end, they are really disappointed in the practical application of this notion by the courts in real life. We should also take into consideration that discrimination is, in theory, widely condemned and rejected in the mainstream discourse in liberal democracies. In the dominant liberal ideology, the formal equality of all citizens is considered a basic principle of all the political and legal system. Therefore, discrimination is seen as an anomaly, a pathology, something that is quite rare and only occurs when the system fails. But in this context, in liberal societies with patriarchal cultures, all of our societies, there are some situations that are normalized because they are related to the mainstream cultural patterns, and they are firmly embedded in the normal functioning of the system. So they cannot be seen as discriminatory practices at all. But there is another perspective or another critique for analyzing this issue. It will be to consider that there are two different paradigms that coexist in our modern notion in discrimination, in the legislation and in the court decisions, despite the fact that they are mutually contradictory. Catherine McKinnon, that has been also referred by Professor Wing and by Professor Macioce, refers to the sex differences approach and the sex inequality approach. I prefer to label them as the individual and social notions of discrimination. For me, it's simpler. The individual notion of discrimination is attached to formal equality, namely the Aristotelian idea of equality, which implies that things that are alike should be treated alike, whereas things that are unalike should be treated unalike. But the problem is, as McKinnon denounces, that in real practice, women are more often than not unlike men. Sometimes biological differences could be relevant. For instance, the Supreme Court of the United States originally ruled that dismissal based on pregnancy was not sex discriminatory. Why? Because they could not determine a term of comparison because they couldn't find, of course, a pregnant man. But anyway, there are many differences between women and men that have been socially created, and they are really important. They have a great impact in our lives. For instance, it is a well-known fact that the unequal distribution of household and care work in the family implies real disadvantages for women in the labor market. Nevertheless, from the perspective of formal equality, this distribution could be seen as the result of individual free choices of many women. This way, the penalization of family responsibilities in the workplace could be seen as non-discriminatory. It's just a matter of choice. You have chosen family instead of work, so you have to assume the consequences. This situation results in the creation of a vicious circle. The greater social differences between women and men are, the greater is the oppression, the more justified the pejorative treatment of women will be from a legal point of view. And this is a problem. As a consequence, the individualistic notion of discrimination tends to protect only, as McKinnon says, the exceptional individual whose biography approximates the male one, or women who for all purposes are socially men, but not the women that are the object of stronger victimization by the system. On the other hand, of course, we have an alternative paradigm for understanding the legal concept of discrimination. So the social perspective. From this perspective, we could say that this sex discrimination consists in the systematic disadvantagement of women. Okay. In that way, the problem is not that sex in an abstract way is an arbitrary criterion for distinguishing between people. The real problem is that women in particular have been historically mistreated, and they still are mistreated. But although this concept of discrimination seems to be more appropriate for fighting women's oppression, it has some disadvantage, in my opinion. It could be confused with sociological and political categories, weakening its usefulness from a legal point of view. For instance, of course, we could say that the unequal distribution of care work in the family is discriminatory. But when this distribution is formally adopted by individual choices, how could we grant the right of not being discriminated in the courts if we cannot find anyone liable? We cannot sue patriarchy. We cannot sue the system in courts. In my opinion, the legal concept of discrimination has to be accurate, precise, and operative in court, which implies that we could not abandon the idea of liability nor the perspective of the agent. But the problem is how to do this while maintaining the social perspective of discrimination. I will try to summarize my position in two statements. I still have time, so I can summarize. First statement. It is important that we make a distinction between the legal sense of discrimination and women's oppression, or systemic inequalities between women and men. There are different things, related but different. Discrimination, it's just my proposal, discrimination always implies some kind of treatment that could be attributed to someone. Of course, this includes omissive conduct, collective treatment, indirect discrimination, etc. But in the end, we have to find a person or an entity that can be held liable in court. We, as I have said before, we cannot sue patriarchy. That is why discrimination is just a part of the problem, but not the problem as a whole. In fact, it is usually the last resort of patriarchy because discrimination and physical violence usually appear when the symbolic violence of gender patterns is not strong enough to maintain the imbalance of power. In normal conditions, patriarchy is sustained by just gender patterns. When it fails, discrimination appears. It's just in that way, it's a pathology. This implies that anti-discrimination law could be helpful in fighting women's oppression, but it's not enough. We need other tools like sometimes affirmative action and, of course, gender mainstreaming of all social and legal reality. Second statement, but if we talk about discrimination, we should emphasize the social dimension of the legal concept. From this perspective, sex discrimination could be defined as a treatment, omissive or active or whatever, a treatment that potentially or actually tends to put women in a subordinate position in society. This idea could be, it's not just my idea, of course, no, I have, no. But this idea could have an impact on the identification of discriminatory conduct. Also, it could have an impact on the evaluation of affirmative action measures, and perhaps it could affect the usefulness of an indirect discrimination construct. But this is another story and shall be told another time. So thank you for your kind attention.
So the next speaker is Zara. Please, Zara.
Hi, yes, Cass. Can I share my PowerPoint, do you think?
Yes, you can. Yes, you just have the button share down there.
Yes. Can you hear me well and can you see my PowerPoint?
Yes.
Yes. Okay, so I'm going to present this chapter that is kind of like a co-authorship among some authors, which is addressing sociology of law, basically, and gender equality. So there are authors, as you can see, in this chapter, Eva, Valerija, Rakul, and myself, and I will present a little bit about the whole content of chapter and the aim and the structure of the chapter, and then Valerija is going to talk about symbolic representation of gendered symbolic representation. So I will start with the format of the chapter. It's as maybe you know, it's a 3-credit chapter and like a course, and it's optional, has 6 sections. So we have developed it in a way that covers 6 topics or 6 themes. It's quite it's, I think, fairly a big chapter as well. So the aims and objectives of this chapter is to help students understand the key concepts in the social legal studies within law and society, basically gender, sexuality, for example, social reproduction of gender, gendered power relations in law and society, gender regimes, gender politics, inequality regimes, and structural inequalities, including structural violence. As well as gender socialization, segregation, and representation. So we start with introducing these kind of concepts and make the base for better understanding of this chapter and other legal chapters. So there will be some maybe cross-referencing as well in here. Some of it is mentioned by some speakers today, which I have noticed that we also we delve into this concept more deeply, and we unpack them for students in a way that they can understand. So the learning goals for this chapter is to first to address some feminist critical analysis of gender binary system, which was also mentioned again today. So by that we are problematizing or criticizing the gender binary system and the way it is being understood by the law. The nature of law is very heteronormative and binary. So within the feminist critical eyes, we are helping students to have that debunked, this kind of a gender binary system, and also the patriarchal nature of society, which also the patriarchy was mentioned again today as well, and how law can affect the gender social relations and the variety of diverse genders and sexualities within these social structures. But within the social structures of we are focusing on family, education, labor market, media, and political spheres. So it's focused on these areas. The other objectives or the goals is to reflect on post-structuralist way of understanding power. So we try to show that how power is being criticized and decentralized through this kind of understanding of power within feminist analysis and criticism, which power is widely dispersed and is operated discursively, so it's everywhere. It's not just centered around the state, for example, and how feminists approach within the social legal studies have been concentrating on challenging all sorts of implications of these kind of power relations and gendered power relations in law and society that's been dispersed, and has been spread all over society. Again, in this case, it's in the family, education, labor market, media, and the politics. And then also we show how feminist intersectional analysis of this structural violence against women and other groups of people in different kind of categories of gender and identities have been affected, has to be counted into analysis and understanding within the kind of law and society approach. So as you see, I have mentioned the structural violence a few times, so I was happy to see Antonio talking about discrimination and criticizing the concept of discrimination. I will be talking a little bit more, or I will be talking about violence and the structural violence and how this chapter is evolved around these concepts within these areas that I just mentioned. So the main sections are, first we introduce the social legal perspective on gender, and then there will be another chapter on the structural violence in the family and private life, and then the focus will go to the education, and then after that there will be some discussions and understanding of how structural inequalities exist in labor market, and then symbolic representation of gender, which Valerija will explain a little bit more in detail today. And then after that, we will have the gender equalities in the politics and political institutions in this chapter. Obviously, it's not going to cover every detail and aspects of these very big and broad topics, but we have tried to make sure that we give as much as we can to the to make the students capture the gist of all of these themes. So the first chapter is going to talking about the social construction of gender. It's been talked again a lot this from the whole day, from the morning. So I'm not going to talk about it anymore. So we are just opposing. We're saying that how this approach to criticizing this gender binary system means to oppose the essentialist view of gender in law and also in social relations. So we talk about the gender regimes of inequality and what gender regime is in a society or in a system. And after that, the chapter is talking about the patriarchal structure of power. Again, it was mentioned many times today, and how the heteronormativity and limited kind of nature of law and the limited vocabulary that's been used in the law can be criticized or be known to be able to analyze this the relationship that it has with society and see it as a social phenomenon that can be changed and modified, and it's an institution of power. As I said earlier, as an institution of power, but also all over in the whole society, not as just one entity in the social context. Also we are introducing, as I in the introduction, the intersectional approach, and what does that mean, and how it is being used in the process of lawmaking and protection, legal protection and implementation of the law. The second section is looking into private and public sphere. So the structural violence, kind of examining rape, including marital rape and forced marriage. Intimate partner violence, for example, is being discussed as well. Economic violence within this, talking about the equality in the labor market and the enjoyment of family life. This section also talks about the medical system and how violence is practiced and experienced by people in the medical system, especially women as well, covering the legal right to abortion and access to care. The third section also is also developed to talk about the educational system, how the curriculums and the practices and teaching is formed or reinforces all sorts of the gender socializations and gender norms, that also reproduces roles and relations within the education system in the primary and secondary school, as well as the higher education system. So I'm just giving you overviews, as you can see, but I cannot go like in depth, and just this is how this chapter has been, like the sections of the chapter have been written, and the main points of the section. So the fourth section is talking about the labor market, how women's inclusion, which is very, very important, in work also is can enable them to enjoy work at the same time. And also it raises the issues of the inequalities that exist within the labor market that excludes women when they become when they want to enjoy their family life and become mothers and carers of children, for example. So it draws on the gendered and sexual division of labor as well, and this has also happened at intersection with race, gender, ethnicity, ability, disability, and other social positionalities. So all these sections have this intersectional approach as well. So when I mentioned at the beginning that the first chapter is talking about all approaches of criticizing gender binary system and having an intersectional approach and decentralizing power, all these sections have these lenses when they are talking about all these issues. So it's been raised and discussed within this approach. So again, in this section, also important matters such as like gender pay gap, that we know, gender division of labor again, and parental benefits, parental leaves, and childcare is also discussed within the gender equality kind of perspective. So section 5 is, I'm not going to talk about it so much, but Valerija will speak a little bit more about that. It talks about the role of mass media in creating and promoting, maintaining symbolic representation of gender through ideologies, language, culture, of promoting this gendered stereotypes in the public sphere, and also it goes to the private sphere as well, right? They are connected. We cannot separate them as well. So it discusses the underrepresentation of women in media as well, globally, and how that's based on gender inequality. So it shows that how women are represented as also submissive housewives, for example, or sexual objects, mainly because for men to enjoy and fulfill their men's desire, and also portraying how gender roles are devoted to mothers and wives in the mass media, for example. basically the objectification and sexualizations in the public sphere is been lifted here in this section and criticized, and how this can affect the representation of, for example, other more important issues such as violence against women, pornography, and so on, and be maybe like dismissed or not even presented, or the way they might be approached would be the like blaming the victims and women, basically, usually in these cases. So, and then the last section is about law and policy-making processes within the political power, political institutions. So the section talks about the political socialization and political participations, how it is gendered, how this process is gendered in the political representation and implementations of these policies and laws and regulations. The male dominance and the male domination in the political process is raised and is questioned, and also the political practices are discussed, as well as the effects that they can make on the decision making, especially when there will be decision making with regards to gender equality, for example. So how this process is leading or not leading to any gender equality outcomes, for example, such as policies. So the overall approach of the chapter, so I have a diagram here for you to make it easier. We talk a lot about the structural inequalities within a gender system. So if there is a gender system in society, and what is a gender system? Gender system includes all these processes that both define male, female, and other genders, for example, in a different kind of social context, right? You have this gender system, which is based, for example, gender segregations or patriarchy or male supremacy or whatever. So that with the specific gender system, there are these structural inequalities within this gender system that generates multiple forms of structural kind of violence, right? And that happens in combination of private and public sphere. So that's why I say that we can't just separate both the private and public. We have talked about these two in entanglement with each other in this structural kind of inequalities that happens in society at not only the structural level. If we talk about law, it's not just the structural level, but also at the institutional level when they're institutionalized, or when institutions are gendered, when practical kind of processes, like at the medical system, for example, in the medical system, educations, all of these professionals, their practices at the institutional level is kind of like inequalities are reproduced and produced there, as we discuss in the chapter, and that results in like kind of violence that we term it, or we propose this is all sorts of structural violence we talk about. And also the individual also has an impact on in all of that. So so this is like somehow the overall of what is happening in this chapter. So the interplay between social practices, law, and also at the institutions that can result in all sorts of inequalities within a very specific gender system. Well, we have to consider the socio-political context of each gender system, so that also is involved into this kind of framework. So it tries to give an in-depth view of how gender stands as an important element as well in this equation, or in this framework, in studying law and you know, in within society, as we know, gender is very important in law, and law is important in kind of social relations and social practices, which is also reproducing all sorts of gender practices and gender roles and gender positions and gender ideas and all of that. So I'm going to stop here, and I don't know if Valerija is there or if she wants to present or...
Hi, Zara. I'm here. Yes, thank you. Thank you for presenting our paper. So, I would just like to thank to Professor Dragica for inviting me and for giving me an opportunity to participate in the project and also to present our paper in such an important event. Thank you to all participants as well for sharing your ideas with us and for coming in Belgrade also. I would just like to share with you that my prior field of research is sociology of law, especially legal professions and judiciary and legal ethics, so that I'm a quite young research in the field of gender. So these conferences are very important for me and very useful. So thank you once again, and thank everyone. So as Zara already mentioned, together with two colleagues from Cadiz, Eva and Raquel, we wrote our chapter, Gender and Structural Inequalities from a Socio-Legal Perspective, where we analyze different socio-legal phenomena from a feminist prism on gender. So our goal was first to promote equality, and our second goal was to show how widely accepted values and gender roles could shape and basically ultimately define our access to social resources, to professional positions, and basically our social status. We try to address only the main problems and try to contribute to the understanding of main concepts. But however, as we all know, this is a very wide area, a very broad area, so our research was quite limited, only to the specific problems. So I just wanted to point out maybe a couple of things that I would like to share with you and maybe to discuss later. For me was, I don't want to diminish the relevance of the before mentioned topics, but I would like to elaborate more on the question of rape culture, and the symbolic representation of gender in media. Why especially this? I mean, this was my part of the paper, and I was thinking, like, when we talk about rape, we usually talk in the legal context, and we talk more about the definition of rape. We talk about the punishment, the years for the perpetrators, and so on. When we talk in the sociological context, we usually like to say that rape is a pervasive gender-based sexual violence that occurs against all genders and all sexualities. Also, we point out that usually women and girls are most often the majority of rape victims, while males are usually perpetrators. So, but in my opinion, as I teach sociology of law and legal ethics, I think that we need to combine these two concepts in a theoretical and also in a practical way. So for us, it is very important to understand how society react when the rape is happened. In other words, how public opinion is created when rape is happened. So what is the role of media in creating, maintaining, and promoting rape culture, or not promoting and not creating? So, as I said, the role of mass media is very important and very dominant in the main discourse. Why? Because media discourse is also public discourse, saying that it has a normal potential for the reproduction of social relations. So we usually have that like traditional understanding of the mass media communication, that this process is quite linear, that you have a sender of the message, and the receiver of the message. But basically, the process of mass media communication is going like through a couple of phases, such as production, circulation, distribution, consumptions, and then finally the reproduction. So In other words, we can say that the message needs to be told. It needs to become a story before it becomes a communicative event. So when the media says that they just present neutral, objective, and impartial information, this basically is not true, because they are representing it. They are representing an object. They are representing a person to the public, which is not anymore a passive receiver of these messages. Public is an active participant in this process. So how media does this? How media represent gender, especially how they represent women. First of all, as Zara already mentioned, in media we are usually faced with ideology-colored language, and media usually promote stereotypes through different photos. So in this way, they are very important actors in maintaining the male dominance, and they are sustaining traditional patriarchal power relations in society. So this is the first way, maybe the most important one. The second way is when they report on the sexual violence, they use gender insensitive language. Also, there are a lot of misogynistic and sexistic phrases, and also they incline or rely on hegemonic masculinity as a justifying strategy. So when we talk about rape, especially rape culture, it is important to understand this symbolic representation. So just to add a few sentences, rape culture is a concept, it's a sociological concept, theoretical one, that is framed, that could be framed in a society. And rape culture refers to the environment in which women's rape is trivialized, normalized, tolerated, justified, even eroticized through different social, cultural, and structural practices, behavior, and discourses. In other words, rape culture refers to social, cultural, and structural discourses and practices that allow and in different ways also support sexual violence. So when we say rape culture, we usually mean on the environment when perpetrators are not held accountable for their acts, where victims are blamed for being victims. In other words, we are talking about systematically disbelieving in the even happening of this act. Blaming victim for being raped is usually followed with the doubts and mistrust in the occurrence of this rape. And this often results in justifying the perpetrators or rationalizing the rape as a big misunderstanding. Also, one of the reasons for this kind of conduct is widespread opinion that rapists are a specific type of person. This is not someone that victims known before, although 90% of rapes were committed by someone that victim actually knew. So also their belief that rape could happen only to a certain type of women. So maybe this is just one way of talking about the rape in a different way, to make a connection with between the criminal law with the society, and between the understanding of society and how we react when this criminal act happens. So taking into account our time and schedule, I just wanted to raise this question and maybe to discuss more maybe about the strategies and policies for overcoming this phenomena. So thank you, everyone. Okay, now Zara, the floor is yours. Feminist methodologies and gender researches. Thank you.
Okay, yes, hi. I'm looking to see if I can find my PowerPoint to share for you, with you. Yes. Okay. I take it as everybody sees my PowerPoint and all is good. Okay, so this chapter is structured around the issue of gender research and what it means to conduct research with a gender perspective. And also, it discusses the research methodologies inspired by feminist, ontological, and epistemological approaches, which was also a little bit talked about this morning. Again, the format of the chapter is like it's a 4-credit obligatory course, which is given as like it's not elective. I think it has to be compulsory for students to take in this program, and fairly like 23 pages, I think, with references, something like that. Now it is going to be. So aim of this chapter is taking the critical approach to the traditional and kind of a male-dominated research and knowledge production, and with this critical approach, it is discussing how one can conduct research with the gender perspective, through research methodologies that are given by feminist epistemological and ontological approaches, but it is limited to 3 approaches that I will explain later. So the learning objectives and goals is that to show how feminist research methodologies are themselves developed. They have developed in order to contribute to the production of knowledge and social reality, taking into account the experiences of women rather than just male perspective. And it assesses the distinctiveness of feminist methodologies from the traditional and mainstream kind of approach. It also discusses how we can have a diversity and how feminist epistemologies are diverse themselves, and how they have opted for challenging the power structures from different points of views, which was, I think, again mentioned this morning, talking about feminist post-structuralism and feminist liberalism and feminist post-colonialism and so on. So there are different epistemologies and methodologies within feminist research or research on gender as well. So the chapter also emphasizes on, in this chapter, we emphasize on the methods that is qualitatively based, like qualitative method oriented in the feminist research, taking the feminist epistemologies rather than just having the mainstream scientific methods that is looking into variables and statistics without counting gender relations and practices and other elements. And also it's at the end of the chapter, or the second half of the chapter is talking about the practical knowledge and the practical skills, how to write an academic kind of research paper, and what are the necessities for doing this. In this chapter, students will learn. What is gender research, and what does gender research mean? First, the first part of the chapter introduces this notion of gender research and how to conduct it, how to conduct gender research, and how to conduct research from a gender perspective, if you like. So, gender research in sociological studies problematizes the hierarchical power, right? And the relationship, the hierarchical relationship that exists in genders, between genders in social life, everyday life. And also in the gender research tries to integrate the diversity of social structures or underlying forces in social structures, if you like, race, class, ethnicity, sexuality. So all these intersectional perspective that we've been talking about all day, it's included in gender research. That means that gender research does that. So it also addresses the traditional biased kind of it criticizes the bias, a traditional kind of gender research based on alternative methods of qualitative and quantitative studies by feminists. So gender research doesn't only mean that we have to do qualitative studies and adopt qualitative methods. It can be conducted within quantitative also data. Paying attention not just to gender differences, like there are research that's been done with two variables, gender, male, female, that is, the gender research criticizes that, it goes beyond that and talks about captures different complexities and different relations that can exist rather than just being a male and female, which also we talked about all day today. Gender research conducting gender research in terms of looking into law and society, like in the social legal studies. Why is it important to conduct such research, and how do we do that? Well, we could say that the emergence or the growth of gender studies as a field of research also since the 70s, 60s, has contributed to this kind of critical studies of law a lot, and critical study of law as a rule of law of the state. So gender studies have explored law as a social process that is kind of discursively constructed, discursively created. As I mentioned earlier in the sociology of law kind of chapter, we look at that as well. So if we see legal policies as things that are constituted, the policies that are constituted in interaction with social norms and realities that are often gendered. Our realities are gendered, so policies also are gendered, right? Gendered social relations and practices have taken shape through all sorts of socio-historical, political, economic processes. Therefore, gender research helps to tease out the way in which legal and social policies, as well as practices, shape people's lives. Gender as the most important element of social relations. So law as an important and, let's say, constitutive element of people's life, social life, and gender as I said, important constitutive element of human being, these two put together makes the most important kind of reasoning for this kind of research, and important for education, for the educational purposes in law and gender. So this is really important. So therefore, studying a social phenomenon with the emphasis on gender, social phenomenon, I mean law. So studying law with the emphasis on gender in society, and having this interplay with law and society is important, because it analyzes law in terms of its power, its potential, its shortcomings, and the ways that it lacks in society. It also investigates the social realities of gender relations that constructs the law and are constitutive of law. And also it explores gendered social and legal processes as well as practices in legislations, judgments, jurisprudence, and advocacy kind of activities among legal professionals and at this institutional level as well. So this is why it is important to have this kind of research focused on gender. Feminist research methodologies. What is feminist research methodologies and how we do that? I think we know that all. But in this chapter, we say it is introduced as feminist methodologies are emerged from feminist politics. And what is feminist politics? Is feminist theories, ideas, perspective, as well as their practices, as was talked about today by Professor Adrian about critical race theory, feminism. So the practices, ideas create feminist politics, right? And that is very important in how feminist research methodologies are developed. So it shows that the chapter shows that also the way that we talk about feminist methodologies. So as you see, I've put here feminist methodologies because there is no one feminist methodology. There are many feminist methodologies because they come from different ideas and perspectives and thoughts. Feminists have had different perspectives and different ways of looking at society or realities with different eyes. So therefore, different methodologies have developed. So this chapter talks about that and reflects on how women have been marginalized in social and political life. So the feminist methodologies first developed to show how, first by how women have been excluded in all of different spheres in society. It also talks about how dominant norms are criticized, and as well as how male supremacy or superiority in production of knowledge is criticized by feminist methodologies as well. So this is a very important part of feminist methodologies that criticizes the only and male kind of perspective as a traditional mainstream. So feminist methodologies is informed by variety of epistemological and ontological approaches. What does that mean? So we say that how the ways in which one understands the world, like ontology, and then how the knowledge is produced in the world, the epistemological kind of approaches. So feminist epistemologies identify how gender influence our conception of knowledge, how our knowledge is produced, and how our sense of being in the world is affected by gender as well, and practices. Feminist epistemologies problematizes how dominant conceptions and practices of knowledge production exclude or kind of subordinates some groups of people, including women. So it's not just about women. It began with women. That should be said. It's not denied, but then now feminists are talking about other groups of people's knowledge that is not included, like intersectionality is one of the ways. So we then in this chapter it is. The talking about the situated knowledge also is something that it's raised, and this is the central kind of endeavor to feminist knowledge production is the situated knowledge, and the kind of knowledge that reflects a particular position, that the particular position of someone as someone who has experienced something as a knower of that. So everybody knows what is situated knowledge, but just the situatedness, just to say that the situatedness of the subject in relation to power structures is important. And the chapter talks about Donna Haraway's understanding of situated knowledge. So, and also feminist epistemology also focuses on how social locations of individuals affect everyday life and experiences, and how the way they have different experiences in different social phenomena. So factors like, as we talked earlier as well, so the intersectionality of gender, sexuality, ethnicity, and other social positionalities are taken into account in gender research and feminist epistemologies in knowledge production. Knowledge production from these points of perspectives. So this is how feminist epistemology is helpful and that's why we focus on feminist epistemologies in gender research when we conduct gender research. So this is just to let the students know the way we frame feminist epistemology. What does that mean? How knowledge is produced and how they are being positioned in how a subject or an object is positioned in the work. So, and then, so as I said, this chapter is limited to just like a number of feminist methodologies. So we couldn't cover every approach or every methodological considerations within feminist methodologies. So the chapter talks about the feminist standpoint theory, feminist post-structuralism, and intersectional feminism or feminist intersectionality. I'm not going to go through what each of these and what they mean and how they. So there will be some descriptions on how they have to how this kind of methodologies is developed in the chapter. The chapter describes all of that and the development and the growth of these kind of methodologies and what does it mean and how. But now I want to just mention how these approaches and these kind of feminist methodologies have been adopted and applied by feminist social legal scholars or feminists in feminist social legal research. They have also, the feminist legal methods are strongly infused, as we say, it's feminist legal methods. They are infused and imbued with the feminist theoretical and methodological approaches, so that they explain how feminist legal methods have adopted, for example, this standpoint theory. The chapter explains how they have adopted post-structuring, for example, approach and intersectionality. So within the feminist standpoint theory, for example, the scholars have adopted this way of asking, for example, women questions, which draws on women's experience, and that's what feminist standpoint theory does. Or legal scholars have talked about practical reasoning, putting women's point of view and experience in context and drawing on the experiences when addressing cases in the courtrooms. And as well as consciousness raising, for example, the experience of collective empowerment that's been also used by feminist legal scholars and social legal scholars as well. Like, for example, the Me Too campaign as a collective empowerment has been used as well in sexual harassment and so on. While gender mainstreaming is a very important kind of maybe methodological or theoretical as well consideration that feminists, social legal and legal scholars have adopted to tease out or to bring out the kind of exclusions and the marginalized group of people within the process of lawmaking and within the process of policymaking, and just question the patriarchal power within this process. And intersectionality as well, that has been adopted in discussing, for example, anti-discrimination laws and gender-based violence in Europe. So these are discussed in the chapter, but also with examples of cases to make it more clear for students to understand and capture what does it mean that we say that feminist legal scholars have adopted feminist kind of methodologies and how and in practice. So as I mentioned earlier, also then the second part of the chapter is talking about how to do this kind of research empirically, like in practice. So they will learn about this different kind of research that can be conducted, whether theoretical or empirical based on field work, and it could be quantitative and qualitative research. So these will be explained, and there are descriptions of this kind of formats or methods of research within feminist methodologies, and then it focuses on the qualitative research. But within the qualitative research, it is also important for the students to learn how a feminist researcher positions themselves in relation to the subject that they do research on, or how they have to have this kind of reflexive approach, not to be trapped into these power relations, and also reproducing what we criticize all the time, that reproducing this objective truths, like kind of like when in the process of knowledge production. So this positionality and reflexivity is so important in feminist research, that is also emphasized in this chapter, that when you go to the field work, when as a feminist you're doing research on such very, very, very sensitive issues, for example, like in sexuality, gender, or anything else, you don't want to like be involved in a kind of unequal power relations and put down the subject and have a hierarchical kind of relationship. So it is also mentioned how in practice this can be challenging, but that can be done well. So the research ethics as well. So it's also connected to positionality, but also the ethical approval and the permissions, how to go about researching when you go to the fieldwork, or conducting interviews, or having informations that are very sensitive. For example, collecting informations that might be very risky or dangerous to the life of the researcher, as or the participants, the research participants, for example. So, but before that, before going into depth how to write up this, the students will learn how to plan the research first. And what does it mean to plan a research? The research strategy. What is the research strategy? And then it shows that you can have a social legal kind of strategy in the research when you conduct gender research, for example. And then how
Zara, excuse me, just sum up, because people are very tired and we have to have also our questions and answers. Just make this. Just conclude,
I think,
please.
Yeah, okay. So this is my last, actually. So the interview, there will be some discussions about what is interview and document analysis and collecting data, and then discourse analysis and thematic analysis as the method of analysis are talked about. So they will learn how to write academic papers with a critical approach and an analytical approach, and how to structure a paper. So that's it.
Okay, thank you. Questions for all concerning all these chapters? So this critical methodology, maybe you should like to because
Thank you, Dragica.
But because I read excellent paper of Rosemary just directly about that, critical legal studies and methodology. So I believe that you would like to add something.
That's really unfair. Right. Well, I mean, thank you, Zara, for the paper, and it's obviously very difficult to comment without having read the paper in depth. So obviously,
just adding
Zara.
I
understand. Yeah, but I mean, there are a number of sort of questions and comments and thoughts going through my head as Zara was presenting, but it was such a rich and sort of detailed presentation that I found it. I was sort of think of one thing and then jump onto something else. So excuse me if I don't have my thoughts very coherently formulated in order to respond or to comment on paper. But I think that perhaps I'll come back to the feminist judgments projects and talk about how this might connect with feminist judgments methodologies. And I think that this possibly relates to some of all of the papers in some way, that we analytically draw these distinctions between different categories of feminist thought, liberal feminists, radical feminists, cultural feminists, post-structuralist feminists. Zara talked about, feminist standpoint, post-structuralist feminists, intersectional feminists. The paper from Antonio and Fabio talked about, different phases of feminist thinking and so on. And in some ways, I mean, they're heuristics. They enable us to systematize our understanding of feminist theoretical and methodological approaches. But I have to say that I'm a skeptic about the value of those categories, because I think that in practice, and certainly the experience from the Feminist Judgments projects is that it's not helpful to think, right, I'm going to do this kind of feminist approach or that kind of feminist approach. It's more sort of starting from the ground up and saying, what does this case call for, and what is strategically useful in the context of this particular, set of issues or this particular problem. And so, in some ways, I think, and I think the paper that you're referring to, the paper that I wrote about critical legal feminisms in the handbook on critical legal theory, was really talking about a kind of post-categorization stage, in the sense that we're not sort of so worried about theoretical purity, but hybridizing all of those things. And in some ways, when we go back and look at earlier feminist work, the categories that we've imposed on them subsequently actually don't really fit if we look at the detail of what was there. So I recently, for another project, was revisiting a very early feminist text, which is Germaine Greer's The Female Eunuch. And Germaine Greer is a sex-positive radical feminist, which is kind of like, we would now think that was an impossibility or that was a contradiction in terms, but she is, she's a radical feminist, but she believes she believes in sexual enjoyment and the need to liberate women from the sort of constraining notions of sexuality that exist in society. And so I do think that in our practice, I find it more productive to get beyond or to hybridize or to, take a magpie approach to using different kinds of theories rather than worrying about, am I this category or am I that category? And that's maybe a provocation that other people might want to respond to. But I try in my teaching not to talk about the categories so much as to just say, well, here's a particular issue and here's how you might approach it. Because I find the categorization of different feminist waves or different feminist approaches a bit sort of intellectually limiting. And I'd like to be able to kind of mix and match depending on what seems to be useful in a particular context. And perhaps that's a more postmodern approach in a way, because we can never say in advance what is going to be the outcome or what is going to be the best way of dealing with something. We have to do it and see what happens.
So most important is to do that, to imply gender perspective or gender lenses, of course. Questions, comments? Before ending, if you let me just a few words to add to what Fabio and Antonio spoke about. So I was the member of that team for creating the course and chapter, but I did not. So we have a fantastic combination of three colleagues from Örebro, from Sweden, Spain, and Italy. And then what I did, I wrote my contribution for this another book, and dealing with feminist reconsideration of political theories. And so something what is complementary to what they spoke about and many other speakers. So my point, I think that's interesting to say, because it's complementary, but also has something specific, maybe to have the others also in mind. That is, so first assumption is the whole pre-modern political theory, by definition, was how to say, colored by maleness, because the patriarchal matrix, or however you want to call that, was the dominant one. However, the modern political and contemporary political and legal theory, so pre-modern also including theory of natural law, but modern political and contemporary political and legal theories are much more the problem. So the time of multiple points of view, not the dominance of patriarchal mindset, but also there is that counterposed emancipatory mindset related to gender equality issues. And then what I, how to say, put the focus on is, okay, in the modern and contemporary times, there are again some theories like populist ones, extreme right-wing, neoconservative, often neoliberal to a certain extent theories, which again do reproduce the maleness, this the sexist approach to gender equality. So again, they reproduce the logic of subordination and something what was in the past normal for them is reproduced with an intention to still be normal. However, for me, the biggest problem is that theories of human rights, of constitutional democracy, theories of democracy, that most often, again, reproduce this approach with a lot of maleness embedded. So there is the problem. So they can be reconsidered, and it's important that authors, male and female, from this field, the field where the potential for emancipatory approach is obvious, that they change their mindsets and to start thinking from these gender lenses or from gender perspective. Because somehow automatically it happens that authors, either male, even female, very critically oriented or progressively oriented authors from the field of constitutional law, human rights law, that they forget this approach. So it's important to remind them.
Thank you for giving me the word. I mean, I don't have a specific question because I've read all of these articles and I'm quite pro this critical legal approach and then applying into different contexts, feminism, feminist legal studies, racist legal studies, queer legal studies. So something which, I mean, especially in this region, we have never done this, as I'm aware, as also Dragica said, we never had this kind of critical legal approach. I mean, we had it maybe, we used to talk about it, but we never had it within the curriculum, or also this applied, I mean, how to apply this method when coming, when researching, specifically, for example, gender issues. And I like this Zara's construction methodologies. And this is quite important, actually, that also this chapter, also this article, but also this master said they're going to be open for different methodologies. It's very important to have this in mind, that reconsideration or recategorization is also very important. So also to have this open space when researching about different gender issues, specifically having in mind this intersectionality. I also wanted to add, Adrien Wing said, we also need men. This is also very important, like to also not also to take these gender issues from a feminist perspective, but also critical analysis of masculinity, something like this, because you can't fight gender stereotypes only from the female side, but you also have to because liberation is not only female side, but it also should be on the male side, because there are also some stereotypical gender roles which a male should, activate or fulfill, so to say. So if you don't liberate, if you only liberate one side, if you leave this other side, you're not gonna. So like this openness also to masculinity, also to somehow like to have this, like you have to have these both sides, so to say. And also the last thing which I want to say, I mean, when also Adrian was telling, and also Zara, like these different ways of critical legal theories. Maybe for our context, maybe Southeast Europe is this ethnopolitics, so critical analysis of ethnopolitics, and actually how the ethnopolitics. I mean, I'm talking about our region. That means Serbia, Bosnia and Herzegovina, Croatia. So this ethno-nationalistic approach is actually also is very embedded with very strong gender stereotypes. And I think this methodology, which Zara has also proposed, and also your paper gives this opportunity to take this contextualized pattern. I mean, like context actually, in order to reconsider gender positions. Yeah, thank you.
Thank you very much. I think what Damir said at the end is the perfect conclusive summing up. Word, and for today, I think I'm very satisfied, but I think we worked a lot and we deserve a bit of rest. And at 8 o'clock, I will show you, somebody will show, my young colleagues will show also to our guests where the restaurant Madeira, it's very close, 5 minutes from here. And those from our faculty who said that would come, so we will meet at 8 o'clock there. You have some time, hotels are close to the faculty, so you have some time to breathe and
have a shower.
Take a shower and fresh air, and then we will go for meal there. Restaurant garden, restaurant garden of Madeira. So see you later, and thank you for it. Tomorrow we will start at 9:30.
9:30.
Thank you very much.
Thank you.